Good morning, children. Welcome to the new session. I hope you all are ready to take your classes of legal studies further to a greater height. As you know, the importance of this optional, basically legal studies in your life, practical life, day to day life. The first unit of class 12th legal studies begins with judiciary. Children, you are well aware with the importance of judiciary in our life. And remember, when you started discussing very first day, basically under the CBSE curriculum, from class 6th onward, you start discussing civics, what we say in 9th and 10th political science. So judiciary you must have discussed as the part of your standard 6th civics curriculum. Now we are moving ahead. Whatsoever you have discussed there, that our government consists of three organs: legislature, executive, and judiciary. The third organ is known as the judiciary, and here we do have a complete chapter, judiciary, as we are well aware that nowadays when government who does have all the rights to make law, legislature is there to frame law, but judiciary is known as the guardian of our fundamental right. Yes, the guardian of our fundamental right, the guardian of our constitution. In case of violation of our rights, in case of violation of any provision of Indian constitution, we go to judiciary. Here under judiciary, you will discuss in detail the different aspects of judiciary, and in this chapter under the judiciary you will discuss the concept like the concept of a common law, the concept of a adversarial system of law, the concept of a due process of law. Generally nowadays we hear about public interest litigation, what we also say as social action litigation. Popularly these are known as PIL or SAL. Thereafter, impartiality of judges. Children, judges or judiciary is highly impartial, and it is mandatory for the functioning of good governance, for the functioning of the governance in a neutral way, that judges must be impartial. That's why judges are highly impartial in Republic of India. Then the concept of judicial review, power the way it has been separated. Okay, that comes under the separation of powers. Fine. Among the different organs of the government, the way powers had been separated, we do have the limits drawn for all the three organs: legislature, executive, and judiciary. They are not supposed to interfere into the affair of each other, but the moment one tries to supersede or cross one's limit, then other will interfere. Okay, then powers had been divided, and the moment one crosses or tends to cross one's limit, then the system of under the system of checks and balance, they are being checked immediately, they are being balanced immediately, so that the normal functioning of the government must not disrupt. Then the basic structure of the constitution, about that you must have discussed in your standard 11th political science as well. Those basic structure of constitution you will discuss once again. And then the system, what is known as the collegium system in appointment of judges, the way judges are appointed, for that we do have a system that is known as the collegium system. We will discuss in detail what does this collegium system consist of, what is this all about. And finally the impeachment. Suppose any judge, though rarest in the rare case, they try to cross their limit and they are violating the oaths that they have taken at the time of being appointed. If they try to supersede it, if try to violate it, then we do have a process given in our constitution, that is the process of impeachment, means the way we can remove them from their post. Fine, children. So about all these concepts we will discuss in this chapter. Now first we will discuss about structure and hierarchy of courts in our country. In our country, India, certainly in Republic of India, what structure we do have of our courts, what are the hierarchies in fact, that we are going to discuss. Very first thing, children, hierarchy is just like a ladder like a structure, that what comes next, who is at the bottom, what is its foundation, and then we need to move ahead. So our constitution, the Constitution of India, lays out the framework of the Indian judicial system clearly. Every minute detail had been given in our constitution. In case of any kind of doubt, one can refer to the constitution and the person will get the solution. Or if any kind of doubt the person will have in their mind, it will certainly disappear within a moment. Children, about the federal system, the federal structure you have discussed in your earlier classes. Our country has adopted a federal system of government. It means that the power had been distributed. The law enacting power had been distributed between the central government and the state government, between these two organs of the government. And most importantly, our constitution establishes a single integrated system of judiciary. Okay, single integrated system of judiciary. It means that the system of judiciary in our country, we do have from the bottom to top, it's only single system, integrated system of judiciary, from the lower court till the apex court till the Supreme Court. And this system of judiciary, single integrated system, comprises of courts to administer both central and the state laws. To administer central laws and to administer state laws, we do have this system. The Supreme Court is located obviously in our capital city, New Delhi, country's capital, and Supreme Court is known as the apex court of India. Remember, children, the term the apex court, the highest court in fact. And then it is followed by various high courts at the state level, which function for one or more number of states. High court generally or ideally one state must have one high court, but sometimes with one high courts their jurisdiction gets extended over more than one state also. And the high courts are followed by the district and the subordinate courts. These districts and subordinate courts are popularly known as the lower courts in our country. Okay, the district court and the subordinate courts, they are known as the lower courts in our country. And apart from these complete structure of judiciary, hierarchy of judiciary, we do have some other specialized tribunals. In fact, these specialized tribunals, they supplement, they assist to adjudicate sector specific claims. Yes, children, remember it's the sector specific claims like labor sector, consumer sector, service matter related disputes. To settle it, we do have the tribunals, specialized tribunals, so that the burden of the judiciary could be eased. In fact, we know what kind of burden, what kind of burden our judiciary used to have. Means our judiciary is certainly overburdened, children. You are well aware that number of judges in the Supreme Court of India, or the number of judges in the high courts or in the lower courts, they are limited, and we are having n number of pending cases till date. Fine. Now, as far as the apex court, the Supreme Court is concerned, okay, Supreme Court is the apex court of our country. Okay, this Supreme Court came into existence on January 28th, 1950. Yes, on January 26th, 1950, India became a republic, and just 2 days after, on 28th January, our Supreme Court came into existence. And this Supreme Court replaced the Federal Court of India. Before the inception of the Supreme Court, we had Federal Court of India in our country, and the Judicial Committee of the Privy Council we had. Yes, children, the two courts we are having before the Supreme Court of India came into existence, it was the Federal Court of India and the Judicial Committee of the Privy Council. These two were at the apex of the Indian court system under the colonial era, under the British government. The moment on January 28th, 1950, Supreme Court came into existence, it replaced both these setup that were rather the Federal Court of India and the Judicial Committee of the Privy Council. The Constitution of India, as it stood in 1950, it envisaged, it gave the provision of a Supreme Court with a Chief Justice and 7 judges. Remember, 1 Chief Justice and 7 judges. Means as the provision had been given, total number of judges were 8, including Chief Justice of India in the year 1950, the very year Supreme Court came into existence. Fine. And I hope you are able to recall the first Chief Justice of India, first Chief Justice of Supreme Court of India. Yes, children. Justice Mr. H.J. Kania. Justice Mr. H.J. Kania was the first Chief Justice of India. And thereafter, our Parliament was granted the power, our Parliament has been given the power to increase the number of judges in the coming years, and it was mandatory in fact. So, at present, the total strength of the Supreme Court is 31 judges, including the Chief Justice of India. And the present Chief Justice of India is Mr. S.A. Bobde. Fine. So, children, some questions had been given in the form of the assignment. Very simple question I had given. You must write its answer, and in case of difficulty of finding its answer, you can consult me. Okay, you can ask me, I will provide you answer, though most of the answer you will find in the content what we have discussed. Okay, thank you, children. Now, second day, we will discuss about the high courts and the lower courts in India. Yes, children, below the Supreme Court, we are having the high courts and the lower courts in our country. India, Republic of India, consists of 24 high courts at the state and union territory level. At the state level and at the union territory level, we are having 24 high courts. Each high court has jurisdiction over a state, a union territory, or a group of states and union territories. It may be that one high court is having the jurisdiction over one state and one UT, or only one state, or a number of states and union territories as well. Below high courts exists a hierarchy of lower courts functioning as civil courts and criminal courts, as well as the specialized tribunals. Yes, about the tribunals we have discussed in first day also. During our class of first day, we discussed about the tribunals. So some specialized tribunals were also there. And most important thing, children, we are having the some high courts, 4 high courts rather. They are known as the first 4 high courts in India. Yes, children, the Madras High Court in Chennai, Bombay High Court in Mumbai, Calcutta High Court in Kolkata, and Allahabad High Court in Allahabad. Yes, students, keep one thing in mind. Generally, High Court used to be in the capital city, but it is not necessary that every High Court will be situated or located in the capital city. And the best example is the Allahabad High Court. Okay, Allahabad High Court, certainly Allahabad is in Uttar Pradesh. Ideally, it should be the Lucknow High Court, but we do have High Court in Allahabad, and we are having one division bench in Lucknow. Okay, not the full-fledged High Court we do have in Lucknow. So these are the first 4 High Courts in our country, India. Below it, we are having the lower courts, district and subordinate courts. Yes, district and subordinate courts are known as the lower courts. These districts and subordinate courts, it function, or we can say the courts that function below the high courts, they are popularly known as the lower court. Okay, and they comprise of district and subordinate courts. Each state is divided into judicial districts. Presided over by a district and sessions judge. Okay, must be very clear in your mind that each state is divided into judicial districts, and these judicial districts are presided over by a district and sessions judge. Okay, now you may ask me that then is there any difference between the district judge and the session judge? Yes, children, when any judge presides over a civil case, means when a judge starts hearing the cases related with the civil affairs, then the judge will be known as the district judge. And when a judge hears the case or presides over a criminal case, any cases are being heard by a judge related to criminal offense, then the judge is known as the sessions judge. I hope it must be clear to you. Now, under this district and subordinate courts, another term that is very important for you, that is metropolitan sessions judge. Yes, children, the district judge, when he or she is presiding over a district court in a city which is designated as a metropolitan area by the state government, is known as metropolitan sessions judge. It means that any area or any city in a district, any city or any district or any area will be designated as a metropolitan area by the state government. And if it happens so, then the judge who hears the cases, rather who presides over those metropolitan area, then that judge is known as metropolitan sessions judge. To assist district judges, to assist a district judge, we do have some additional district judges also. Okay, and depending upon the judicial workload, if workload is more, then it is mandatory to appoint more additional district judges also, so that the burden of the district judge could be eased. Fine, children? Then the district judge, if we say that below a high court or below a high court judge, what is the highest or who is the highest judicial authority? Then undoubtedly the district judge is the highest judicial authority below a high court judge. Okay, and the district court also holds appellate jurisdiction. Appellate jurisdiction means any cases, any matter, after getting verdict from one court, we do have right to appeal till Supreme Court, but directly from a lower court. If a lower court has given a decision, directly one cannot go to appeal in the Supreme Court. From a lower court, the person will go to the subsequent next hierarchy. Okay, before going to Supreme Court, going to High Court is also necessary. Fine. So the district court also holds appellate jurisdiction and supervision over all subordinate courts below it. Okay, apart from these subordinate courts, we do have the district municipal courts also, children. Okay, before going to the district municipal court, the district court, as we know, holds the appellate jurisdiction. On the civil side, we do have the subordinate courts below the district court, include in ascending order the junior civil judge court, principal junior civil judge court, senior civil judge courts, that is also called the sub courts, subordinate courts on criminal side. These were of the civil sides. Now on the criminal sides, in the ascending order, we had second class judicial magistrate court, first class judicial magistrate court, and then the chief judicial magistrate court. Yes, these are of the criminal side, children. And as I told earlier, that we do have a district municipal courts also that form a part of this hierarchy, that apart from the subordinate courts. And the district municipal courts are the lowest in order of handling matters of civil natures and function below the subordinate courts. Yes, below the subordinate courts. They do have some pecuniary limits as well, some monetary limits, some financial limits, what is known as the pecuniary limits, that the court's ability to hear matters up to a particular claim for money, that till this amount are, and these amounts, these limits are being fixed or notified by the respective state governments. Clear? So I hope I am clear in giving you these basics of the lesson. Now some assignments you do have, children. Very simple questions I had put in those assignments. Okay, like you have to name the first 4 high courts of India along with its year of establishment. Then how many high courts we do have in our country, who presides over a judicial district. Okay, what do you know about the Metropolitan Sessions Judge, and some other questions are there. So only one simple classification I am going to give you, I am going to add about the bench, division bench and the constitutional bench. Okay, children. Bench, a group of judges sitting together on a legal matter in the court. It constitutes a bench. Yes, when a group of judges sitting together on a legal matter in the court constitutes a bench, and the lawyers constitute the members at the bar. Lawyers are the members of the bar. Okay. Now division bench comprises of 2 or 3 judges. Minimum 2 judges it's necessary, and 2-3 judges. That will be known as the division bench. And the third concept is of the constitutional bench. Constitutional bench comprises of 5 or more judges, and it may even extend to 13 judges. In the crucial cases, in very high profile cases, we have seen in the past also, and it will be in future also, constitutional bench is being created, constituted, and those constitutional bench, they give the verdict by majority of judges. Okay, thank you, have a good day.